The administrative law area is obviously complicated, but it's our job. And it's complicated by things like Chevron. It's complicated by our willingness to say, oh, let the expert agency decide, and then give them all this running room. But I do think that when we don't review things, we abdicate our responsibilities.
So the Supreme Court will decide an important case which will help bring an end to the ATF's current overreach and their attacks on the Second Amendment. So let's talk about this. But real quick before we jump into this video, if you think it's time for more pro two-way wins out of the Supreme Court, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is MyBookie. This month, college and NFL football is once again back, and so your chances to win with MyBookie are now available. NFL and college football and a brand new cash out system gives you the option to bet and win on these NFL games and college games if you want to this season. MyBookie allows you to bet safely and securely on all games if you want to enhance that viewing experience. I know some people like fantasy football. I love fantasy football, and some people like to bet on games when they're watching them. And again, it just enhances your viewing experience if you would like. To get started, you can go to mybookie.ag and register for a free account. And when you're ready to make your first deposit, you can use the promo code SCHOLAR to get a 50% deposit bonus for free. Again, use promo code SCHOLAR to claim that free 50% deposit bonus, and make sure you bet responsibly. And thank you again to MyBookie for sponsoring this video. So as I mentioned in the intro, in this video, we're going to be discussing an important case which the Supreme Court has granted review in and will decide on this next term. This case is not a Second Amendment lawsuit, but it has huge implications for the two-way cases and litigation that's going on right now against the ATF and other agencies which are attacking our right to keep and bear arms. This case can help stop the ATF's pistol brace rule, their bump stock ban, their frames and receivers rule, and the new rule that they're putting in place, which is targeting private party transactions. This case is called Loper v. Raimonda, and this is a lawsuit which aims to bring an end to Chevron deference. Now, the facts surrounding this case are as follows. Loper Bright Enterprises, or LBE, is a family-owned herring fishing company that operates out of New England. The company is engaged in herring fishing, and it takes place on a very small boat. On these small boats, every inch of space is very valuable because they need to store supplies, and they also need to store all the fish that they catch. However, the herring industry in this area came under attack because of a new rule that was issued by the National Marine Fisheries Services, or the NMFS. This new regulation and rule that was put in place requires that these boats must have an additional person on board to serve as a monitor. The rule requires that this additional monitor be on the boat so that they're in compliance with the tracking and compliance regulations and rules that were put in place. Not only does this monitor take up space on the boat, but the fishermen must also pay that monitor's salary, which is estimated to be around $700 a day. Loper Bright and other fisheries sued and challenged this rule, arguing that there was no statutory authority to essentially force them to pay and have these monitors on board. On review, a district court held that the statutory text did authorize this new rule. Loper Bright then appealed, and the DC Circuit Court held that the statute was ambiguous, but then the court deferred to the agency's interpretation under the doctrine of Chevron. Loper Bright then filed a petition to the Supreme Court, and the Supreme Court recently granted review in this case, and the order of the Supreme Court stated that the petition for a writ of certiorari is granted, limited to question 2 presented by the petition. Now, question 2 that the Supreme Court is referencing in their granting of the petition is essentially this question, which is whether the court should overrule Chevron or at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute does not constitute an ambiguity requiring deference to the agency. So the Supreme Court, in granting this case, will hear a case and decide whether or not they want to overrule Chevron deference altogether, or at the very least, are they going to greatly limit the ability of an agency to use Chevron when a statute is silent on an issue? Now, if you're not aware of what Chevron deference refers to and why this is such a big deal, Chevron deference is a term coined after a Supreme Court case called Chevron versus the Natural Resources Defense Council. This case established the concept of courts upholding agency interpretations of ambiguous statutes that Congress has tasked that agency with implementing. However, generally, for an agency to be given Chevron deference, the agency's interpretation of that ambiguous statute must be rational or reasonable. Now, in contrast to Chevron deference, there are other concepts that are used sometimes. For example, the rule of lenity, which indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous statute in a way that is most favorable to the people, not the enforcement agency. There's also another concept called the major question doctrine, which the Supreme Court has been using very much recently. They used it recently in the West Virginia v. EPA case, and then a different EPA case, and they recently used it also in the student loan decision. Under the major question doctrine, the Supreme Court declared that if an agency seeks to declare an issue of major national significance, its action must be supported by clear statutory authorization. What the Supreme Court indicated in West Virginia and some of these subsequent cases is that the agencies will no longer be afforded broad Chevron deference when their actions have vast economic and political significance. Now, you may be asking yourself, why is this important for the Second Amendment context? Well, right now we're seeing agencies like the ATF and others creating rules and being very aggressive against our right to keep and bear arms. For example, in just the last 5 years, we've seen the ATF go through various rulemaking processes, put in place various rules, banning bump stocks, attacking pistol braces, treating bump stocks as so-called machine guns, treating force reset triggers as so-called machine guns, targeting braced pistols or firearms with braced pistols on them as SBRs, going more aggressively against homemade suppressors, going against unfinished frames and receivers with the new rule, and then also through the Bipartisan Safer Communities Act, creating a new rule which is targeting private party transactions. So the ATF is all doing this under rulemaking processes, and they're using something like Chevron as the underpinning and the foundation to put in place these new rules. If Chevron is completely done away with, the ATF's claims that they have this type of authority to put in place these rules will no longer be valid. Multiple Second Amendment organizations know that this is very important, so they filed amicus briefs to the Supreme Court in support of the Supreme Court striking down Chevron deference once and for all. FPC in their amicus brief states that Chevron deference violates the federal Constitution's separation of powers and thus undermines the framers' constitutional design. Chevron violates Article 3 by transferring from the judiciary to the executive the ultimate interpretive authority to say what is the law. It violates Article 1 by incentivizing Congress to abdicate its legislative duties and delegate legislative authority to the executive. As a result, Chevron accumulates legislative, executive, and judicial powers in a single branch of the government, which the founders considered the very definition of tyranny. Chevron should be overruled. GOA in their brief argues that the historic rules of statutory construction have been dramatically altered by the Chevron court, placing a heavy thumb on the scale of justice to uphold decrees of the administrative state against the people. So from a two-way context, many organizations are jumping in with the hopes that this case will finally bring an end to Chevron deference. The government recently filed a response brief in this case, arguing that Chevron deference is a bedrock principle of administrative law that must be followed by the Supreme Court. They state in their brief that overruling Chevron would be a conclusive shock to the legal system. All three branches of government, regulated parties, and the public have arranged their affairs for decades with Chevron as the backdrop against which Congress legislates, agencies issue rules and orders, and courts resolve disputes about those agency actions. Given its central importance, they argue, overruling Chevron would threaten settled expectations in virtually every area of conduct regulated by federal law. They also argue that under the principle of stare decisis, the Supreme Court is bound by Chevron and must not overrule or do away with Chevron because of stare decisis. They claim that if Chevron is overruled by the Supreme Court and if it's done away with, then there will be chaos within Congress and then also executive agencies. So like I said, although this case does not deal directly with the Second Amendment with firearms issues, it does deal with a major legal principle that has been used against us in multiple 2A cases and has been used by courts to uphold things like what the ATF is doing with pistol braces, frames and receivers, and other actions. A positive decision in this case will help future 2A cases, especially those that are suing the ATF because of their new rules. And the government knows how important Chevron deference is so that they can get away with what they want to do. And doing away with Chevron would greatly limit the type of rules that they're putting in place, which infringe on our fundamental rights. So this is a huge case going forward. We're going to be keeping our eyes on this. Again, this has been accepted by the Supreme Court. They are going to decide this. This case hasn't been set for oral argument hearings yet, but it's going to happen very soon. We'll probably see that hit the docket very soon. So as we get more information, as things develop, I will let you all know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.